All right, good afternoon or morning, everyone, depending on where you are joining us from today. My name is Jennifer Maffett-Nickelman, and I am a partner in Thompson Hine's Corporate Practice Group. I would like to welcome you to today's webinar. This is the fifth in a series of webinars targeted at issues that businesses face operating in a COVID-19 world. Our next scheduled webinar is June 9th, and it is titled Environmental Compliance, Operational Best Practices and Risk Mitigation Strategies. Registration information will be available in the next few days. We are planning additional webinars as topics arise. To sign up for those webinars or any other, please visit our COVID-19 task force page, which you can find at thompsonhine.com. Before we begin, a few housekeeping items. Today's program is being recorded. We will send a link to all attendees within 48 hours of our presentation. If you have any questions during the webinar, feel free to use the question box located in the control panel on the right side of your screen to submit questions. We will answer as many of those questions as we can at the end of the webinar. We will be offering CLE credit for today's webinar. Please be sure to fill out and return the webinar affirmation form that can be found in the handout section of the control panel, again located on the right hand of your screen. The form provides instructions as to where to send the completed form. You will need a tracking code, which I will announce at the end of the program. In the handout panel, you can also download a copy of the PowerPoint slides and bios of today's speakers. Again, thank you for your interest. If you have questions as we go along, please use the question box. I'm delighted to introduce my colleagues that will be presenting with me today. Joining me are my partner, Rich DeBari. He's a partner in our business litigation practice, and John Mitchell, a partner in the white-collar criminal practice, internal investigations, and government enforcement practice. Rich is going to start off our program today with an overview of what we're going to cover. Rich, take it away.
Thank you, Jennifer. Today's presentation is called Paycheck Protection Program Loans, making sure you don't have to beg for forgiveness. It'll be broken down in three parts. I'll begin by providing an overview of the PPP loan program and where we stand today, with information regarding borrower eligibility, specifics on loan terms, and the loan forgiveness structure unique to these PPP loans. I'll provide that context so that Jennifer Maffett-Nickelman can then turn to the focus of today's presentation, walking through the specifics of very new information released by the Small Business Administration this past Friday regarding specific new loan forgiveness rules and new information regarding the forgiveness application process. Jennifer will also share steps borrowers should take to optimize chances at obtaining forgiveness. Finally, our colleague John Mitchell will then round out the presentation today regarding the risks associated with PPP loans, audits, civil penalties, and even potential criminal liability. John will also offer tips to mitigate the risk of having to seek a very different type of forgiveness. Next slide. So for a high-level overview of the Paycheck Protection Program, this was initiated with the CARES Act passed by Congress. Congress allocated $349 billion in loans as a lifeline available for eligible small businesses through the SBA and overseen by the Treasury Department. Due to its initial popularity, after those funds depleted, Congress since enacted new legislation to allocate $310 billion more for the program. As of the date of this presentation, approximately $100 billion remains available for new borrowers. The PPP has gained such popularity because it is structured as loans through lenders, which are backed by the SBA and the U.S. government, which are forgivable. Those loans turn into grants if borrowers use them for certain purposes. Primarily, that is to keep people employed. Through the CARES Act, the PPP was established and is bolted on to existing SBA rules and frameworks, particular to their existing Section 7A loan program. The SBA has existing regulations and rules which the PPP bolts onto and which crop up from time to time, such as the affiliation rules, which we'll discuss briefly, And unless changed by the CARES Act or Treasury, the SBA rules underlie all of the PPP program. One thing to note, another important and new tool available through the SBA are an expanded use of the Economic Injury Disaster Loan Program that was also changed in the CARES Act. A borrower can obtain a PPP loan and an EIDL so long as the loan funds are used for different allowable purposes. What makes the PPP program so popular? Very favorable loan terms for the borrower. There's complete deferral of all payments for the borrower for 6 months, including interest. The PPP waives certain fees and the requirement to show the unavailability of credit elsewhere that are usually standard for SBA loans. That is, in order to obtain an SBA loan, you need to demonstrate as a borrower, usually, that there are no other funding options available. That requirement is dispensed with, but, as we'll talk about later, is not completely irrelevant. Unlike most SBA loans, PPP loans do not require a personal guarantee or collateral by the borrower. There are no prepayment penalties associated with the PPP, and forgiven amounts in the legislation itself are deemed excluded from gross income for federal and state tax purposes. However, under current IRS guidelines, pursuant to a recent rule that it issued, PPP loan funds are not deductible as a business expense. That is, if you obtain funds and use it for payroll or non-payroll purposes, they are still not includable as a deduction in your tax returns. That may or may not be addressed going forward, but that is the current rule. For those amounts of your loan that are not forgiven, the interest rate is a uniform 1% payable over 2 years. But all borrowers, whether for an existing PPP loan or when they're considering taking, should be aware of restrictions in pre-existing loan agreements that they might have. The borrower will be taking on additional loans, and there may be provisions at issue in pre-existing agreements that'll either prohibit or be relevant to this borrower taking on new loans. So who is the PPP for? What are the eligible borrowers? With many exceptions, the PPP is for small businesses generally defined as 500 or fewer employees. That includes employees of a borrower's affiliates. Those affiliation rules were found in pre-existing SBA regs and reaffirmed and reincorporated by Treasury and the SBA here. Why does eligibility matter now? You may wonder, I applied for the loan, the lender sent the loan funds to me. It appears that everyone agrees that we are eligible. That is not necessarily so. At the end of the forgiveness process, as we'll talk about later, there will be a determination whether you were and are eligible as a borrower. That will be a precondition for having forgiveness granted. So it matters now. Be sure indeed that you are eligible. Other borrowers who do not meet the 500 or fewer general employee size standard may be eligible under other SBA regulations to qualify as a, quote, small business concern, end quote, by meeting alternative size standards included in SBA regulations. Finally, PPP loans are capped at $20 million in the aggregate to any, quote, single corporate group defined as businesses majority owned directly or indirectly by a common parent. Next slide. Another consideration for determining whether a borrower is eligible is the, quote, necessity certification. All PPP loan applications require borrowers to certify in good faith that their PPP loan requests are necessary. What does that mean? Midstream, long after certain loans were processed, the SBA released guidance, and it states, Borrowers must make the certification in good faith, taking into account their current business activity and their ability to access other sources of liquidity sufficient to support their ongoing operations in a manner that is not significantly detrimental to the business. Next slide. After releasing those, a frequently asked question and those guidelines providing borrowers with the standards for their assessment on whether they really need these PPP loans, the SBA also provided a safe harbor deadline to return funds if a borrower thereafter determined it did not meet the necessity certification. If a borrower returned their PPP funds by May 18, 2020, a date that has since passed, the SBA made clear that they will have deemed that borrower to have made the certification of necessity in good faith. That applies to borrowers who returned the funds by the safe harbor deadline. For borrowers who did not return funds, implicitly they are readopting their necessity certification. What this means for the borrowers who returned the funds and for those who kept the funds and the readoption of the necessity certification will have great import, and much more on this later. So that's who's eligible. What are the allowable uses of the PPP loans? PPP loans are permitted only to be used for the following types of business expenses: payroll costs, as defined, and we'll cover that in a second, and specific non-payroll costs, generally interest on mortgage obligations, rent, utilities, and servicing pre-existing debt interest obligations. Note, all of these are permitted uses of PPP loan funds. But servicing pre-existing debt interest obligations, that fourth category there, is not a permitted forgivable use of those funds. You cannot include those payments in your forgiveness portion. Instead, all of the other ones may be used and included in the forgiveness application. There is a prohibition on using PPP funds for any other purposes with great consequences. Next slide. So what are payroll costs? The PPP broadly defines payroll costs well beyond just salary or wages. It includes compensation such as salary, wages, commissions, bonuses, and payment of cash tips or equivalents for all employees whose principal place of business is within the U.S. It also includes soft or fringe benefits paid by the employer, payment for vacation, parental, family, medical, or sick leave, allowances for separation or dismissal, payment required for the provision of group health care benefits, payment of any retirement benefits, and state and local taxes paid by the employer are included, but federal payroll taxes are excluded. That said, employer withheld federal taxes owed by the employee are included in payroll costs. There is one cap. The maximum of $100,000 of wages per employee prorated over the covered period. Now that is only for the compensation piece. There is no cap, prorated or not, to the amount of benefits that can be included in payroll costs. Next slide, please. Non-payroll costs are also defined. These include mortgage interest payments on any business mortgage or obligation on real or personal property that was incurred before February 15, 2020, but not any prepayment or payment of principal. Note that this is a mortgage obligation on real or personal property. Rent is also a non-payroll cost. It is for real estate or non-real estate assets under a lease agreement in force before February 15, 2020. And utilities are payments for gas, electricity, water, transportation, telephone, or internet access for which service began before February 15, 2020. Those are all includable as a permitted use, and all of those payments within an applicable period may be included for loan forgiveness. Generally, loan proceeds used for those purposes in an 8-week period beginning on the date you received the PPP funds plus accrued interest are eligible in the pot toward forgiveness. However, those amounts spent are subject to some rules. What specific amount will you be forgiven for? Those rules, or that amount, is subject to the 75-25 rule, which I will cover in a second, and two reduction formulas put into place by Congress so that the paycheck part of the Paycheck Protection Program is put first. That is, a borrower who received funds is to look back at the amount of employees and wages paid from a certain look-back period compared to how they used the funds during the covered period. If there are not reductions in wages or workforce, then all of the funds that were spent can be forgiven, subject again to the 75-25 rule. If there were decreases in headcount or wages, then a reduction formulas will be employed to the total forgivable amount. Jennifer will walk you through how to do these calculations. Thankfully, just this past Friday, the SBA released guidance on specifics for the forgiveness rules and formulas, and they also released a very helpful template loan forgiveness application. Next slide. I mentioned the 75-25 rule. What is that? 75 refers to payroll costs and 25% refers to non-payroll costs. That is, the SBA enacted a rule, not in the CARES Act itself, but the SBA enacted a rule that costs other than payroll costs can be no more than 25% of the amount of the loan forgiven. The goal instituted by the SBA here was to ensure that the majority of loan proceeds are used for payroll costs going to reduce unemployment. Skipping to the second example, here's how that plays out. If your loan amount was for $1 million and during that 8-week covered period, you only incurred $600,000 in payroll costs, whether it be because that is just what your circumstances of your business required or you had some sort of reduction in headcount, that maximum amount of loan forgiveness, you take that $600,000 amount, that now becomes 75% of your total forgiveness amount, which is now $800,000. $200,000 is for non-payroll costs, $600,000 is for payroll costs. That is your maximum forgiveness amount, then applying the two reduction formulas. Jennifer, once again, will walk you through how to make that calculation. We mentioned all these rules, and we want to make sure that you, the listener, understands that this is current as of today. What you are hearing today is current as of the recently released guidance from this past Friday, and it is current. That said, there are legislative changes perhaps coming to the PPP. In the House and in Senate, they're considering changes to the length of the covered period, from extending it from 8 weeks to perhaps 16 or 24 weeks, or maybe abolishing that 75-25 rule altogether. We are uncertain as of this time, but the legislative changes could come as soon as 2 weeks from now, or of course, not at all. We encourage you to watch this space. Also, as I mentioned, that loan forgiveness application, and Jennifer is going to walk you through some of the things we learned from that application and the guidelines. That's available at the website included here in the presentation. It includes an application, a worksheet, and a Schedule A worksheet. We encourage you to gain familiarity with the line items and categories included here. And because the instructions really are intuitive and they lay out in real terms the new guidance issued by the SBA. And now here to discuss that new guidance from this past Friday and freshly baked into this program today is Jennifer.
Thanks, Rich. I would just first like to express my appreciation to the SBA for all of its last-minute and Friday night news dumps. And not to disappoint anyone on the Friday eve of a holiday weekend, they blessed us with 45 pages of new guidance on forgiveness and the loan review process, but it was perfect timing for today. So there wasn't much new, no earth-shattering different treatment for borrowers in the new guidance. But let's talk about some of these details. As Rich said, they've cleared up some of our open questions and provided some specifics on forgiveness. We're going to talk about an alternate covered period for payroll costs that they provided in the application and confirmed in the new guidance. One open question was, if costs are incurred versus paid during the covered period, can they be forgivable? Does it have to be incurred and paid? We think that question's been answered. I'm going to talk a little bit more about the 75-25 split that Rich explained. They did provide some really borrower-friendly methodology for calculation of full-time employee equivalent. We've got a 6-year document retention requirement now. Bottom line is the application and the final rule just issued did confirm most limits on forgiveness, but they did provide borrowers some relief. So first, the alternate covered period for payroll costs. Generally, the covered period is your 8 weeks from the day the loan was dispersed. Several borrowers complained and said this is really difficult because our payroll cycle starts in, we got our loan on Wednesday and our payroll cycle starts the next Monday. So what the SBA has done is said, if that's the case, if you have a payroll cycle that's biweekly or more frequent, you can elect to use the 8-week period of your payroll cycle that begins on the first day of the first pay period following the day you got your loan proceeds. It's only for payroll. You can't use it for other payroll costs. But for payroll, you can align your covered period with your payroll cycle if that makes it easier for you. Next, the open question of costs incurred versus paid, they have answered it pretty explicitly now, and it's pretty borrower friendly. So payroll costs are eligible for forgiveness if they were paid or incurred during the covered period or alternate covered period. As long as they are paid, if they were paid during the covered period, you're all set, they're forgivable. If they were incurred but not yet paid because you have overlap where employees worked for a time during the covered period, but that paycheck date did not fall within that covered period, so long as you pay that payroll on the next scheduled pay cycle, you can include those. Same thing for non-payroll costs. For example, unless by magic your monthly utility bill cycle happens to line up perfectly with your covered period, you're going to have a split month where if you pay in arrears for utilities, some of your utilities are going to be outside that covered period either before or after. The rule is if it was incurred or paid during the covered period, you can pay it. If it was incurred but not yet paid during the covered period, but you pay it on the next regularly scheduled billing date, it's going to be forgivable. So they've made it fairly helpful for borrowers to have some flexibility for what counts and not be completely subject to that covered period. So Rich talked about the 75-25 split. This has been really controversial because it's not in the CARES Act at all. This was simply from a rule that the SBA initiated after the enactment and really after a lot of borrowers had applied for the loan. So as Rich explained, this is a cap on the amount that you can have forgiven because the intent of the program is that borrowers use the money primarily for payroll to keep people employed. So the formula, as Rich said, is take your total forgivable portion of the loan, divide it by, and then take the payroll cost, and divide that figure by 0.75. That will give you your total maximum loan amount. So again, the purpose behind this is to highlight that most of the proceeds of the loan should be used for payroll costs and not for non-payroll costs. We did have a question before the final rule about whether or not your use of the proceeds is subject to the same limit. Could you be found in violation of the PPP loan rules and regulations if you did not use the proceeds in this ratio? We believe the final rule makes it clear that that is not the case. You will be in compliance as long as you use the proceeds for permitted purposes. Even if they're not in line with this ratio, we do not believe there is a risk of a violation of the PPP program requirements, which is important to a lot of borrowers that have not been able to open their businesses yet or have just been able to open their businesses yet and most of their covered period has applied. You may not be eligible for forgiveness, but we don't think you're at risk of a penalty. The new guidance also provided some information on calculating full-time employee equivalent. Again, this isn't a concept that's in the CARES Act. This is in the forgiveness application. And this goes to the reduction in employee headcount that Rich talked about. So if you've reduced headcount during your covered period, there's going to be a reduction on the amount that can be forgiven. But there were lots of questions about how do you determine what's full-time? How do you treat part-time employees? And the answer that the SBA provided is actually pretty borrower-friendly. So 40 hours a week is full-time employee equivalent. Anything less is part-time. They explicitly said in the new guidance, they looked at 30 hours, which is what some people had expected it to be because that's what the Affordable Care Act counts as full-time employees. They said no, 40 hours full-time. Anything less is part-time. But what they said is borrowers have a choice. You can treat part-time employees as a specific ratio to full-time employees. So for example, 32 hours would be 0.8 of an FTE. Or for every part-time employee, anybody less than 40 hours, you can just call them 0.5. You can do whatever you need to do, whatever's easiest for you, with one caveat. It has to be the same. You have to compare apples to apples. So as Rich talked about, in determining the reduction in employee headcount, and we'll talk about this a little bit later too, you apply a method that compares the number of full-time employee equivalents during your covered period to a prior period, and you have a choice of 2 prior periods. You just need to use the same methodology for both, so you're comparing apples to apples. You need to run these calculations. There's an opportunity here. You may be able to hire some part-time employees to boost your employee headcount, your full-time equivalent employee headcount, to help you on the reduction formula. You just got to run the numbers. But there is really good guidance now on how to calculate those numbers. All right, so the first reduction formula that we've talked about is comparing the average number of full-time equivalent employees that you have during your covered period, that 8-week period after you get your loan, and divide it by one of 2 options. It's comparing this time period to a prior time period. You can either pick February 15th to June 30th of 2019, what your average full-time employee equivalent was, or you can compare it to the first 2 months of 2020. Run the numbers both ways, see what works better for you under your circumstances. But you get that percentage, and that will give you what then you would have to reduce your forgiveness. So before we go, we're going to run through the formula, but in this recent guidance, they have given you some helpful exemptions here. Employees that voluntarily resigned or that requested a reduction of hours, that were terminated for cause, or employees that you gave a written offer to return to the same job at the same pay and they said, nope, no thank you. None of those employees need to be counted as a reduction in headcount. Now, one thing we just learned Friday night, for that last exemption, that rejection of a written offer to return to the same employment, in order for you to take advantage of that, you have to refer that employee to the state unemployment insurance agency within 30 days. You have to let them know that they rejected your job offer. Now, if that 30 days has already passed, my suggestion is consider offering them that job again with the understanding they might say yes, but start that clock over again. The guidance is silent on what happens if that time period has not passed, but that's an idea. So any of these where it wasn't your company's decision simply to furlough people or lay people off, where there was cause, where you've offered their job back, or where they quit or asked to reduce their hours, is not going to count against you. So let's look at a formula here. So let's say you got a loan on April 1st, you had 1 full-time employee in April, and then in May you have 1 full-time plus you have 2 part-time employees. So for the 8-week period from the loan origination, you had an average of 1.5 full-time equivalent employees, right? April you had 1, and in May you had 1 full-time plus 0.5 plus 0.5, so that gives you 2. Divide that by 2 months, you've got your 1.5. let's compare back to February of 2019 to June 30th. During that time, you had what you had in May. You had your 1 full-time employee and your 2 part-time employees, so you had 2 full-time equivalent employees. So you take your 1.5, which is what you had during the covered period, divided by 2, which is what you had in the look-back period, and you get 0.75. So whatever your maximum amount of allowable forgiveness is, you have to multiply that by 0.75. So you will have a 0.25% reduction. This is really significant. So if your maximum amount eligible for forgiveness was $10,000, it's now only $7,500. So the other reduction that Rich talked about is if you've reduced wages. Run your calculations on this. Unlike the employee headcount where there's no wiggle room, you got a 25% buffer on this. If you haven't reduced wages more than 25%, this isn't going to hurt you. This is a per employee allocation. It's not an overall wages. If your wages paid have gone down because your employee headcount has gone down, you're not going to get a double whammy for that. If the reduction in wages is because that position was eliminated or the hours were reduced, that's going to be taken care of in the headcount. This is solely for a reduction in wages without a reduction in hours generally. It also does not apply to any employee who made over $100,000 in 2019. So SBA is worried about what they have determined you're not high income earners. Anybody below 100,000 is what they're focused on here. Now there is, so here's an example. Again, this isn't likely to be applicable to as many people as the headcount reduction. So you can download these slides. This is just an example, but run the calculations on the forgiveness application and just make sure none of that reduction formula doesn't apply to you. There is one big exemption, and this is something you guys really need to think about. For any reduction in full-time employees from February 15th to April 26th, so for that time period, and that April 26th is the magic date, it's 30 days after the CARES Act was enacted. But if your company laid off anybody, furloughed people, terminated employees, if they're rehired by June 30th, or if there were wage reductions, they're restored by June 30th, there will not be a reduction to the forgiveness amount. So, and this is not an all or nothing. If you rehire some of them and you help lower that employee reduction, that comparison from the number of full-time equivalent employees you have in the covered period compared to that prior look back, if that difference becomes smaller, it will help you too. But if you rehire those people by June 30th, it's not going to reduce your forgiveness amount, and that is significant. Because that's just lopping off a percentage of the maximum amount that can be forgiven. So really, really consider whether or not this is an option for you to help increase your loan forgiveness amount. So that's one of our strategies for maximizing the loan forgiveness. Consider rehiring, considered hazard pay and bonuses if you need to boost your covered payroll costs. Again, it's money out the door, but there's a benefit on the side of it that might increase your overall forgiveness amount. And the guidance Friday night made it very clear that hazard pay and bonuses are included in forgivable amounts. Our other suggestion is be flexible. You might want to wait and see how legislation changes. As Rich said, there is legislation pending before Congress. They're negotiating. Who knows if anything will come of it. But one of the items that's being really discussed is to increase that covered period from 8 weeks to 16 or 24. Now, look, if right now you can maximize your forgiveness amount and you can make your entire loan forgivable, there's not really any reason to wait. Fill out your loan forgiveness application, get it in, and get it done. But if you're not at 100% yet, you might want to think about waiting. There may be some legislative help to you that will allow you to maximize your forgiveness more than what's available under current guidance. There's currently no deadline to apply for forgiveness following the conclusion of a covered period. So right now there is no rush to get this done. So you just may want to think about it if you're not at that 100% forgiveness point at the moment. So let's talk a little bit about the actual process. So you file the loan application. Rich said the link to the application is on the SBA's website. It's included in these slides. It's included in our last client alert. So you can go to our website, lots of ways to find it. You fill out the application and you submit it to your lender. You've got to keep for 6 years and include in that file you submit to your lender all of the documentations outlined in that application. And it's what you would expect. It's documentation verifying the number of full-time employees, your federal payroll, tax filing, state income payroll, and then documents verifying your use of non-payroll costs, checks, electronic payments, payments receipts, all of those items you should submit. And then you've got your certification. You have to certify that the documentation presented is true, and the amount for which forgiveness is requested was used to retain employees, make interest payments on a covered mortgage obligation, covered rent, or covered utility payments. You also want to make sure that you have in your files, unless your loan is under $2 million, a written self-assessment of the necessity certification. It's really important that you keep that. As Rich said, for loans under $2 million, the SBA will deem your necessity certification in good faith. So that's not too much of an issue. But for over $2 million, while they have said that necessity certification will not result in criminal or civil penalties, you still want forgiveness, right? So you really do need to have your written documentation of why the loan was necessary for you, because that's going to be still used to determine whether or not the loan is forgivable. So if the SBA, if your loan is over $2 million, the SBA is going to be looking at this necessity certification, and while you may not go to jail if they decide that it wasn't necessary, you'll have to pay it back. So please do make sure you have all of that documentation, both for permitted use as well as for necessity if your loan is over $2 million, and keep it for 6 years. Lenders will not be permitted to approve forgiveness if you have not provided all of the documentation required as laid out in the application. So what are lenders supposed to do when they get these applications? They simply have to confirm that they've received your application, that they have your certifications, that they have the documentation, that your calculations are mathematically correct, and that the 75% of 75%, 25% test is being complied with. That's it. The lenders are not required to look behind the numbers and do their own independent investigation. So the lender will then issue a decision on forgiveness. A couple of issues with that came out in the guidance Friday. There was a separate guidance interim final rule on loan forgiveness, and then there was a separate interim final rule on the SBA review process. And it's not limited to forgiveness, but that's kind of what it was focused on. But in general, the SBA made it clear that the SBA can review any loan at any time. So while they've promised to audit every loan over $2 million, every loan is up to just a general SBA review. And if the SBA is reviewing a loan, the lenders cannot approve forgiveness. The lenders have 60 days from the time that you submit your forgiveness application to issue a decision. They can approve your loan, approve forgiveness of your loan in part or in full. They can deny it, or they can deny it with prejudice because your loan is under review. If your loan is under review and then the SBA completes that review and finds you're eligible, you can resubmit for loan forgiveness. So they're trying to make this a quick process on forgiveness, but if the SBA has selected your loan for review, that's not going to happen. If the lender denies forgiveness, you have 30 days to request the SBA review of that decision. One very interesting note that came out in the new guidance on Friday that is going to be very upsetting to lenders is the SBA has now said if they ultimately determine that you were ineligible, lenders will have to disgorge their loan processing fees. These fees were 1 to 5% of the loan amount, depending on the level of the loan. And these were used to entice these lenders to participate in this program. I suspect lenders are going to be very unhappy. The one lender I have spoken with was rather surprised at this, but be aware of it because it does align the lender now with the borrower on eligibility determination. So if your loan is under review by the SBA, which includes eligibility, you've got a friend in your lender who wants to have the same result that you do. So just keep that in mind. All right, so we know that all PPP loans of at least $2 million will be audited. Affiliation rules apply. So if you have affiliates and your loans together exceed $2 million, you're going to be subject to that audit requirement. Make sure you have your documentation together. And John will talk about that a little bit more as well. Your certification of necessity, again, under $2 million, it seems to be made in good faith. For over $2 million, no penalties, but you still want to get the loan forgiven. So make sure you have your documentation of why that loan was necessary for you at the time you applied for it. Because 6 months or a year down the road, you don't want to be trying to remember what things were like in April of 2020. Make sure you have all of your documentation together. There are certifications all throughout these loan applications, the forgiveness application. Understand that these misrepresentations remain subject to potential civil and criminal penalties. That deemed in good faith for loans under $2 million and for over $2 million, saying that other penalties will not be applied, that is only for the certification of need. That is the only certification covered by those comments. All other certifications are subject to the potential penalties that John is going to warn you about. John, take it away.
Thank you, Jennifer. Good afternoon, everybody. I guess it shouldn't start as any surprise that people are trying to take advantage of the PPP loan process and get their hands on money that they would not otherwise be entitled to. And today I'm going to talk about the framework of what we're seeing in the criminal justice system, its applicability to you and your organization, and some thoughts and some advice on how to deal with specific acts or investigations that may arise as a result of your participation in the program. The government's already started with the low-hanging fruit, and if you were paying attention last week, you saw that Maurice Fain, who's also known as Arkansas Mo from the Love and Hip Hop reality television show, was indicted for bank fraud in violation of 18 U.S.C. 1346. And essentially what Mr. Fain did was he filled out his PPP loan. He signed and submitted to the United Community Bank in the Northern District of Georgia. He stated that he had 107 employees and he averaged a monthly payroll of $1.5 million. In seeking a loan of $3.7 million, he certified that the loan proceeds would be used to retain workers and maintain payroll or make mortgage interest payments, lease payments, and utility payments as specifically specified in the PPP program rules. The bank, UCB, ultimately funded the loan for $2 million. Within days of receiving that loan, Fain allegedly used more than $1.5 million of the loans to purchase jewelry, including a Rolex watch, a diamond bracelet, a 5.73 carat diamond ring, $40,000 for child support, and either leased or purchased a Rolls Royce. Now, I think the understatement of the year is in the press release from the Northern District of Georgia, the U.S. Attorney's Office. They indicated that such payments are not authorized use of PPP funds under the CARE Act. Last week, United States versus Ma was unsealed. It is a case currently pending in the Southern District of New York. In that case, the defendant, a Chinese national businessman, sought PPP loan funding to the tune of about $20 million from 5 different banks. In seeking that funding, he indicated that he was the president of 2 companies that had hundreds of employees and paid millions of dollars in wages to those employees on a monthly basis. In order to support these false representations, Ma submitted false loan applications about the numbers of employees that he had and the wages that he paid them. He submitted fraudulent doctored bank records, tax records, insurance records, payroll records, and or audited financial statements to these 5 different banks. He purportedly represented himself and his organizations as a global entities when in fact he was the only employee of both of the companies. He was indicted, as I noted, and he was charged with 1 count of bank fraud, 1 count of wire fraud, 1 count of making false statements to a bank, each of which carry a potential penalty of $1 million in fines, as well as up to 30 years in prison. He was indicted with 1 count of major fraud against the United States, which carries a maximum sentence of 10 years in prison, as well as 1 count of making false statements to the SBA, another count of making false statements, which carry a 2- and 5-year sentence, respectively. I'm on the Substance, Crimes, Procedures, Conspiracies tab, please. Specifically, this details the 3 different types of crimes that we're seeing in this kind of PPP universe. The first are what I call substance crimes. That's what we saw with Mr. Fain. Specifically, they're charges related to the misuse of legitimately obtained funds. You fill out the paperwork properly, you submit it, you get the funds, and then instead of using them how you're supposed to, you spend them on Rolls Royces and 5-carat diamond rings. The second classification involve what are called procedure crimes. And these are charges related to misrepresentations made in order to obtain funds you otherwise might not be entitled to. And that's what we saw in the Moss scenario, specifically creating and preparing false documentation to seek up to $20 million in funding when you have only one employee yourself, rather than the hundreds you claim. And then the last classification would be conspiracies, where either the funds were not obtained or the funds were not impermissibly used, yet 2 or more people entered in an agreement to commit some sort of criminal act related to the use or the seeking those funds. So when we see these 3 different kinds of statutes involved or classifications of crimes, the Department of Justice isn't going up in a brand new area here. They're really just using the same statutes they've used all across the history to prosecute individuals for financial crimes. Next slide, please. We're seeing the use of the wire fraud statute, 18 U.S.C. 1343, which simply involves obtaining money or property by false or fraudulent pretenses when using a wire, i.e. the internet, your cell phone, television, radio. Any way that a wire is involved that crosses interstate lines can give rise to a charge of wire fraud, which normally carries a penalty of 20 years. But under today's present circumstances and the fact that an emergency has been declared, it carries a 30-year penalty. Next slide, please. Like we saw with Mr. Fain, he was charged with bank fraud for executing or attempting to execute a scheme or artifice to defraud a financial institution or to obtain monies, funds, credits, assets by means of false or fraudulent pretenses. Again, like wire fraud under these circumstances, this carries with it a potential penalty of up to $1 million or 30 years of imprisonment or both. Next slide, please. Under 18 U.S.C. 1014, this is the application process, and this is really what we call a procedure crime. And you can see I've bolded certain portions of this statute and italicized them to emphasize how the Small Business Administration is covered, as well as FDIC, participating financial institutions. And what happens when somebody submits false documentation or fraudulent documentation? It gives the Department of Justice the ability to pursue those wrongdoers. So we've got the procedure crimes, we've got the substance crimes, and there's not one size fits all. But when in doubt, next slide please, the government will charge a conspiracy, which really consists of 2 or more people agreeing to enter into a conspiracy when they know the main purpose, and they are voluntarily intending to help advance or achieve its goals. And this is a much easier case for the government because they don't have to prove that the actual crime was committed, only that 2 or more people agreed to do it, that they took a substantial step towards the completion of the offense. So these conspiracy statutes are rolled into RICO. There's 18 U.S.C. 1349. The Department of Justice has a tremendous arsenal to combat these types of fraud. So when we talked about the certification necessity reminder, again, next slide, please. There you are. You see how important it is that you comply and you participate in accordance with the regulations, because the Department of Justice and law enforcement is paying attention to these. And it's a very salacious case when somebody uses funds that are used to save American businesses to buy Rolls Royces and diamond rings. But there aren't just criminal statutes that are involved. Next slide, please. Civil actions can also be involved, namely the False Claims Act. You might remember this as the Lincoln Law that was passed back in the Civil War, giving private rights of actions to individuals known as relators who can sue on behalf of the government to seek redress for companies and individuals defrauding the government. And simply put, during the Civil War, the United States of America didn't have the resources to chase down all the fraudsters, so they empowered individuals to pursue these types of claims on behalf of the government. The relator gets 30% of the recovery, and often, most exclusively, the relators come from the companies that are engaging in the fraud, and there are anti-retaliation programs in place to protect those people who file those types of claims. Next slide, please. It prohibits making or using or causing to be made or used a false record or statement material to a false or fraudulent claim. And if you go to the next slide, you'll see that the recovery can give the relator and the government up to 3 times the amount of the small business loan. And these are false statements that can include statements made on a loan application that led the lender to approve the loan. And subsequent misrepresentations or representations that aren't wholly true can be used and fall under the False Claims Act, keeping in mind and reinforcing that we have to be scrupulous when engaging or participating in the audit process. Next slide, please. So the takeaways here are very simple. First, take the application and every statement in it very seriously. No matter how much of a time crunch you're under, getting this accurate and getting it correct is paramount. Second, be aware that the loan program's eligibility requirements can change, that this is a changing landscape and it's incumbent upon you to understand exactly what you have to do to comply with the regulations in place. And lastly, remember that government funding always comes with strings. So be aware of those requirements and those strings and make sure that you scrupulously observe the requirements. And since this is a changing landscape, it's incumbent that you pay attention to the regulations as they come out or contact those people who do. So I want to talk about a couple of quick things here as I wrap up. Next slide, please. What do you do when the FBI knocks? Well, look, when this crisis ends, these investigations will surge. We've already seen them go after the low-hanging fruit in the Ma case and in the Fain case, but numerous tips are going to be happening. Grand jury subpoenas are going to be going on, and most importantly, agents are going to be arriving unannounced at the doors of potential targets, subjects, and witnesses. And when government agents arrive at your door, it'll be early in the morning or later in the day at a time when you were designed to catch you unaware. They will present badges, ask to speak with you, and ask to enter your home. And most importantly, it's very simple what you do in those situations. That is, exercise your constitutional rights. Politely, but firmly indicate that you're not going to speak with them and that you are exercising your Fifth Amendment rights. Ask for a business card. Indicate that your attorney will call them. Next slide, please. And do not waver when the agents say things such as, this will only take a few minutes. We don't want to make a big deal out of this. Nobody comes to your house at 6 o'clock in the morning by accident. They're there for a purpose, and they already know what the objective is they're trying to achieve. And keep in mind that when you speak with these agents, that there's a specific statute, 18 U.S.C. 1001, that is designed to prosecute those who make material false, fictitious, or fraudulent statements or representations to law enforcement. Remember that Martha Stewart did not go to prison because she broke the substantive law, but she went to prison because she was convicted of lying to law enforcement. This is a process that is designed to gain leverage over you. Be mindful of that. The last few slides deal with insurance considerations. And this is the time for your company to check your insurance policy and see the amount of coverage you have to deal with investigations such as this. It's important that you know that investigations can be expensive. An investigation involving even a moderately sized company would require individual attorneys for each of the executives involved, pool counsel for those group of employees that the government wants to investigate or at least speak with, and an attorney for the company. And very quickly you can have 2, 3, 6, 10, or even multiple more attorneys involved in this type of investigation, depending on the amount of people involved in the case and the allegations against the company. And understanding that you have the proper insurance for this type of investigation, and that the terms and definitions are broad enough to cover not only when an indictment is issued, but all of the information and all of the activities that would take place prior to the issuance of an indictment is paramount. Otherwise, you could find yourself with a potentially million-dollar liability, as numerous employees are seeking legal advice that the company is obligated to provide. So next slide, please. So make sure you understand how broad the terms claim is underneath your insurance policy, and investigation and loss, and what those mean and how they're defined. And so lastly, my takeaways here are very simple. Make sure you understand your Fifth Amendment rights, that you're prepared to use them if you receive that unwanted, unexpected knock on your door at 6 o'clock in the morning or 7 o'clock in the evening. And as those of you, on behalf of your organizations, make sure you understand the insurance coverage that is tailored towards these types of situations, and that it's in place, and you understand the terms and definitions and the limitations thereof, because this is truly one of those circumstances where an ounce of prevention is worth a pound of cure. Jennifer?
Thanks, John. All right, we'll now begin the question and answer session. We will address as many of the questions as we can in the time remaining. If you are seeking CLE for today's program, the tracking code is TH0526. Again, that code is TH0526. If you have additional questions after the webinar, feel free to email or call your current Thompson Hine lawyer, who will direct you to a member of our COVID-19 task force. If you are not a current Thompson Hine client, please contact one of us. We can discuss with you options to address your needs. All right, so I've got some questions coming in. I'm going to try and see if I can direct these to the right people. Paid time off. If paid time off is incurred but not paid during the covered period, can that be forgivable? So if it's just employees that are accruing normal vacation time during that covered period, but it's not paid out, can that be included as a forgivable cost? Rich, my inclination is no. What do you think?
I agree. I would say that is incurred, but unless it's going to be paid out then or in the next pay cycle, as you talked about in the alternative covered period, then it would not be included.
Note terms for any amount not forgiven that has to be paid. Rich, do you know, is it amortized over 2 years? Is there a balloon payment? Do you know exactly what the repayment terms are for amounts not forgivable?
That's going to be specific to your lender loan application and the specific loan terms there. The only thing mandated by the SBA and Treasury was 1% in 2 years. Everything else is specific to your actual loan documents.
You have to look at the note you actually signed. I think most lenders were using a pretty simplistic SBA note form, but you'll have to look at your actual note to see. There was a question about transportation costs, whether gas for company vehicles can be forgivable. Rich, I think that's in your column too. Thoughts on what transportation costs would mean? Utility costs, can we use gas? Can gas for company vehicles be used under that? This
is a tricky one, and there's a couple questions that I see in the list on this issue. The way the utilities rule is worded is any expenses made for access to water, internet, electricity, etc. So access to transportation, which is one of the items in that serial list of amongst water, electricity, etc., doesn't really make sense. So I think that will be one of the very few items that will be subsequently clarified by the SBA. I don't think there will be a lot of them, but I think that one will be subject to an upcoming FAQ, because right now it is unclear.
Question about what can you use for an alternate covered period if you have multiple payment cycles? That's not addressed in the new guidance. I have seen nothing that suggests that you could have different covered periods. My guess is if you pick a payroll cycle and use the covered period for the borrower, everything is going to be governed by who your borrower is, right? So there was one entity that the loan was obtained under. So look at that borrower, and for that borrower, pick a payment cycle. I don't think you could have multiple ones for a single borrower, but I think the guidance is so long as it fits within that requirement, if you pick that one, and then you can't double dip. You can't pick an alternate covered period, but then use payroll costs incurred for that time period you're going to have between the time you got the loan and the alternate covered period when you start your 8 weeks. You can't double dip there. But I think if you pick one based on any of your payment cycles, that's probably going to be okay, with the caveat that the guidance doesn't address that possibility. Question about we talked. Yeah, go ahead, Rich.
Jennifer, we have a request for you to repeat the code, the concluding code, and before you do that, I see a number of comments or questions here about the downloading of slides. We're aware of the issue. When you receive a follow-up email, they will either be included or something alerting you to where you can access these slides will be included. So we'll make the slides available to you.
And that code again is TH0526, TH0526. If you're not receiving our updates and invitations, we do invite you to go to our website, register to receive our mailings under the publications tab. We'll take a couple more minutes, answer a couple more questions, understand we're over time if you need to drop off. Just a couple of more questions that have come up. Is there guidance for independent contracts and sole proprietors? And the answer to that is yes. There's additional information in the forgiveness application and in the new guidance that was issued Friday that talks about self-employed individuals and owner employees, about Schedule C and how to calculate your payroll costs. So I encourage you to look at that guidance. There is a question about hourly workers. Is it based on number of hours or hourly rate for determining any reduction? If you haven't reduced the hourly rate, then I don't think there's any reduction of wages. If you've reduced the number of hours, I think under the new calculation of full-time employee equivalent, 20 hours is going to be the same as 30 hours, can be treated the same as 10 hours. If it's less than 40, it can be part-time, and you can treat all of them as 0.5. So my take, and Rich, let me get your thoughts on this, is if you haven't reduced the hourly rate, there's no reduction. And if they were already part-time and they're part-time with less hours, I don't know that the formula would calculate that as different. Run through the numbers and the calculation in the worksheet. But Rich, any thoughts on that?
No, I would have nothing to add to that.
Last question, FMLA, can that be considered a voluntary reduction of hours? If it's paid FMLA, I don't think you have any issue. If it becomes unpaid FMLA and they're simply not there, not working, I don't think that would be counted as a termination or furlough. I do think that would be a voluntary reduction. I mean, I think they're still employed. If they're on FMA leave, they're still an employee. So I don't think it reduces headcount, and you haven't reduced wages. If it's unpaid, it's just unpaid under your policy. I don't think that's a reduction in wages. So I don't think FMLA would count against you. Rich?
Agreed.
Okay. All right, thanks everybody. We'll get the slides out to you. Again, thank you for your time and your interest in attending. Good luck to all of you. Enjoy the rest of your day, and please stay well. Thank you.